I would like to ask you as a professor, how would you react to a student who submitted an exam with a one-sided and biased account of the facts that included only the facts supporting the student's view and omitting everything else?
What we did here with respect to Mr. Sessions...
I'll get into the facts for a moment.
Yes.
Just
so I think
you will indulge me and answer the question.
Right. So I think it would depend. If the question were to the student, is grabbing a woman by the genitals sexual assault or not, and they responded, yes, it is, I would say that's a correct answer. If they responded by saying, no, I wouldn't characterize grabbing a woman by her genitals as sexual assault, I think that's a stretch, as Mr. Sessions did,
I think
then I would say that's not a good answer.
We'll get into the facts and substance in a moment.
Senator Cruz tried to catch you on something. Was there some substance there, or was this kind of a semantic jousting match?
I think it was a jousting match. Senator Cruz was attempting to try to demonstrate that we were, in some sense one-sided, but in fact, a number of the things that he said we omitted from our testimony were right there in the testimony. So what we were presenting was our concerns, and our concerns are the acts that Senator Sessions has taken in abusing prosecutorial power and his failure to take seriously the rights that he's responsible for enforcing, and we presented those concerns.
You blasted Senator Sessions for prosecuting African-American civil rights leaders as a U.S. attorney in the 1980s and insinuating that doing so somehow made him a racist. And yet, you did not mention in your written or oral testimony the fact that the complaints asking him to do so were brought by African-American citizens who felt that their votes were being abused and stolen.
As a prosecutor, when he exercised the power to prosecute, the most serious power that any government official in the United States exercises, he abused that power.
As this committee is well aware of the infamous Marion 3 case in which civil rights activists were prosecuted by then U.S. Attorney Sessions for voter fraud, all of whom were acquitted by a jury in less than 4 hours on 29 counts. This chilling prosecution against innocent civil rights workers who were later given gold medals by Congress painfully reverberates in the hearts of black voters in Alabama and the history of this country.
Sessions said that it was African-American politicians who first brought this to his attention, and that's why he went after that.
Well, listen, every prosecutor has the responsibility of assessing the veracity of allegations brought to them. Every allegation brought to you does not substantiate a case. To simply say that black people brought you an allegation which serves as sufficient pretext to suppress and cause people to be fearful about exercising their right to vote and to prosecute falsely 3 innocent civil rights workers does not make sense as a matter of common sense, nor as a matter of law.
This same committee in 1986 rejected Senator Sessions for a district court judgeship based on his actions and words at that time. We're now 30 years on. He's taken further actions. Those actions, I think, raise more concerns about his record, and they do not assuage the concerns that were dispositive back then. I think the Senate has to take that very, very seriously. This is someone who was not deemed fit to be a district court judge. The question is now, is he fit to be the nation's most powerful law enforcement officer?
The would-be judge's biggest problem came in a case he prosecuted and lost, a vote fraud case involving black civil rights leaders in Perry County, Alabama. Defendants in the Perry County case were Albert and Evelyn Turner, political and civil rights leaders for more than 20 years. Albert was an aide to Martin Luther King. Their scrapbook has all the marches.
This is Bloody Sunday. Albert conceived. That's him right there.
The federal government charged the Turners with doctoring absentee ballots, vote fraud, and mail fraud.
My own opinion is that the case was political. I actually don't think Jeff Sessions and them came in with an ounce of evidence.
The case was tried last summer. Albert and Evelyn Turner were found not guilty. Jeff Sessions declined to talk to NBC News, but his friends and supporters told us he is not a racist. And the Justice Department says Sessions had a good case. Jack Drake disagrees.
I didn't think the government had a case. The impetus of it, I think, was to keep blacks from voting, to intimidate people, and they went right after the leadership that they want to defeat.
And my question to you, Mr. Cole, is in your written and oral testimony, why did you omit the fact that the complaint came from African-American citizens, from elected African-American incumbent politicians, and the indictment came from a grand jury that was a majority African-American? Why did you omit those facts?
Well, I don't think I intentionally omitted those facts, Senator Cruz. What I did was to express our concerns about several aspects of that case, namely that Senator Sessions, as the U.S. Attorney, investigated only counties, not just Perry County, but only counties where black votes had gone up. Not where white votes had gone up, but only where black votes had gone up, number one. Number two, that he had conducted the investigation in an extremely intrusive way, addressing black voters at their homes, asking them how they voted, why they voted, etc. Number three, that he took the position, the legal position, that advising somebody on how to vote, on who to vote for, was a crime. Now, you, Senator Cruz, when you were running for president, advised people on how to vote.
Well,
for
you
yourself.
also admitted the fact that the evidence in the case showed absentee ballots had been tampered with, and indeed the defendant in the case admitted that he had changed absentee ballots. He argued it was with the voters' consent, but he admitted he had changed absentee ballots.
Right, and if you're
and my point is simple, Mr. Cole. This committee can assess what occurred there, but any law student or any litigant who presented such a one-sided picture of the fact, conveniently omitting every single fact that is to the contrary, would not be treated as a credible witness and would not be treated, as you describe your testimony, as strictly nonpartisan. Let me turn briefly to a second issue you brought up, which was the type